What did you expect when you were invited to come here?
Well, I knew this was Jackson country. I've obviously followed him. Youngstown Sheet and Tube Company versus Sawyer is a common citation on national security law that we use almost every day. Obviously, followed his. I have in my office the soaring opening statement at Nuremberg that four great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law, is one of the most significant tributes that power has ever paid to reason. So we're imbued with it. In our office, we have pictures of the Palace of Justice and the defendants and the judges, and it's part of our everyday life.
Did you learn that in school too, as you were going to Harvard and then worked your way through? Was Jackson taught then?
Yeah, and we wound up reading in constitutional law and other disciplines, Greg, opinions of his. In Korematsu, you mentioned his amazing opinion, extraordinary opinion there, and so we had came across him in legal history with Brandeis saying that he should have been Solicitor General for life. I mean, we had Solicitor General Freed there when I was there, and Archibald Cox was on the faculty. So, took an interest in appellate advocacy as a law student. So you're looking at great appellate advocates, and Jackson was just one of the greatest. Could take a very complex issue and boil it down to something really, really simple but powerful and elegant. So, I had that kind of respect for him. It wasn't until I became a practicing judge advocate, and then I went to the International Operational Law Division at the JAG School and was teaching war crimes. So I wound up having to, immerse myself in Nuremberg and the subsequent proceedings, but the London Charter and the history of that I came to know him and understand more of that part of his legacy.
You're going to be a lawyer? Was that something you sought when you were in college? This is
not even close. Not even close. I was an infantryman. I was an infantry officer.
So West Point and. Yeah. So what was the tipping point?
I had an infantry platoon in the 82nd Airborne Division, Greg, and I was very, very interested in rules of engagement. So this was the mid 80s. We're in low intensity conflicts, no non-combatant evacuation operations, different kinds of operations other than war, other than full scale war. And it was something that struck me as an area we just weren't very good at. We couldn't give guidance to troops that would enable them to act with the proper balance of initiative and restraint. Make no mistake, we had a lot of wonderful troops, a lot of wonderful leaders, but I thought as a matter of doctrine and training, we could do better. So I became very interested in rules of engagement and in a kind of a training approach to it. And so I had been to England on a scholarship after West Point and had taken a couple of legal theory, legal jurisprudential theory, and had become somewhat interested in being a JAG. Went back to the 82nd, was an infantry officer, got interested in rules of engagement, and came to the view that I needed to maybe go to law school. So that's when it happened, about 4 or 5 years into my Army career. But I was an infantry officer before that. So
you get into law school, and did that cast your source that you were going to stay in the service and continue the practice law?
Yeah. No, it was the best of both worlds. I loved the Army.
Yeah.
I loved service. And being a judge advocate allowed me to do the law while still being in the Army, and it's been a wonderful ride.
JAG, just for the camera, but was that principally criminal or civil, or insofar as
it's a combination of disciplines. It's what the Department of Defense and the Army need in their lawyers. So Certainly, the early practice was all criminal law. I mean, it was trials, courts martial. But we have to assist troops with legal assistance. We have to run a claims program, so troopers can bring claims for certain types of damage on their moves. There's a Tort Claims Act. There's a foreign claims if we're in a foreign country, and so there's civil law in that regard, basic tort law. We have a large body of administrative law. We out-process soldiers for adverse reasons or otherwise. We have a lot of civilian employees, so we have labor law. So it's a very diverse practice, and you kind of wind up getting your feet wet and all that as a general practitioner in the JIA Corps. In the 90s, when I got into it, was sort of the birth of a modern discipline of international and operational law. And having been an infantry officer, having kind of a natural rapport with commanders and troops, and having had, kind of made my, earned my spurs, if you will, in criminal law and trials, I then sort of decided to deploy with units and try to assist commanders in targeting decisions, in compliance with the law of war while using force, and in all the myriad things that come up if you're deployed on foreign soil. And that discipline of operational law really became a discipline in the 90s and early this century. So that's kind of where I wound up, and it's heavy on international law because a lot of that involves compliance with.
You were one of the first disciplinarians, or first into that discipline, weren't you? As far as
Dave Crane was there, Mark Warren. There's a group of us, Mike Newton. A bunch of us were sort of thinking the same thing, and we were trying to systematize it, trying to capture lessons learned. There's a Center for Law and Military Operations at the Judge Advocate General School, which tries to capture those kinds of lessons, issue publications that are kind of legally rigorous, but also very practical, handbooks and this kind of thing. And I was the first full-time employee of that in the 90s, and so wound up studying in detail operations that I hadn't personally gone on, but that were like ones that I was to go on. So I was happily part of that development.
When you, of course, I've seen your picture, Brigadier General Mark Martins. I mean, with all of the ribbons and stuff, and that's no doubt for many things, but certainly your infantry work. And did you find that going from one area, now you're in the Judge Advocate General, which is more of a advisory legal aspect as opposed to deployment aspect? Was that a difficult change for you?
Well, not really. I mean, you need to think as a commander must think in order to give him good advice or her good advice. I mean, so it was a pretty natural fit, and it was a time when commanders were starting to grab their judge advocate and bring them into the Tactical Operations Center and seek advice as an enabler. You were gonna be providing a no answer on occasion, but usually what you were trying to do was get ahead of the issue enough, find out what the commander needed to do, and help him do it lawfully.
9/11 occurs. What's that do to your world?
I was the staff judge advocate of the 1st Armored Division in Wiesbaden, Germany. And, we immediately got accountability. I had some troops that were on leave in the States, so we immediately found out where they were, got the families together, family support group, told them what we knew. There was a lot of security on bases all across Europe. Wonderful outpouring of support from the German people initially. And we started, frankly, training and doing exercises for something that would come. So we started getting ready for things. And then we wound up deploying to Iraq in spring of 2003. So it definitely changed the world for us. Yeah.
As far as the legal system is concerned, at this point, detainees, they're capturing people, they're sending them to Guantanamo. What's that do for the Judge Advocate General? There's no manual for this, was there?
Well, no, I mean there was. I mean we used to have to treat detainees humanely. There were questions early on in Afghanistan about whether to treat them as subject to the Geneva Conventions, and whether we should use it's called an Article 5 tribunal, which is a tribunal for sorting out what you have, what kind of detainee you have. So there was some disputes over whether we should use that kind of system that we had used in Vietnam and we had used in a number of conflicts. But no, I mean the detainee operations, we had fallen out of practice. We didn't have units that were trained and ready to provide the humane care and custody. But no, it wasn't an unknown discipline in the law. But we had law for humane treatment. But we had a lot of detention operations starting in Iraq.
So as those were you being diverted somewhat at some point into what became pretty controversial issues regarding what were they to be treated as, prisoners of war, what rights, etc. Was that a kind of a separate unit within a unit, or?
Yeah, I mean, I was, Greg. I was on the chairman of the Joint Chiefs of Staff legal counsel's office, and then went to Iraq, and wound up went to Iraq a second time and wound up seeing a lot of detention operations and also Iraqi detention operations, and then went back again to Iraq a third time and spent 2 years there when at the height of the surge, when the number of detainees really swelled to over 30,000. In order to get stability. Now we brought all that down all the way to nothing by 2011, but we were doing a lot of law war detention, and then the Iraqis were detaining people. At one point, we were close to 70,000 detainees in Iraq. Not just Americans holding them, but the Iraqis is holding them as well on basically law of war authority. So these weren't people you had picked up as a result of a criminal investigation. So we all kind of got tugged into this because I had done so much field detention ops in addition to targeting and criminal law and other things in the operational sense. I wound up getting kind of drafted in January of 2009 to be on the President's Detention Policy Task Force as Secretary Gates's day-to-day executive secretary for that. So I spent about 10 months in the Department of Justice, worked in DOJ. I was between tours. I had finished my tour in Iraq in 2008. So I was between tours, and then I wound up getting deployed to Afghanistan then that fall. So yeah, and then I was in detention. I went to Afghanistan to essentially to implement the detention policies we had formulated across the U.S. government on detention policy in Afghanistan, because we had the detention population had swelled there, and we formed as a result of General McChrystal's request for a detention command that could take over that whole difficult area. He asked in August of 2009 for a joint task force. Became Joint Task Force 435. I was just getting promoted to Brigadier General in the JAG Corps, and General McChrystal and General Petraeus were essentially asking me to come over to be the deputy commander to a Navy SEAL, Vice Admiral Harward. It was a 3-star position. He needed to get congressionally confirmed. I was a 1-star. They gave me the interim command from about September to about November. So I was the first commander of JTF 435, which took responsibility for detention ops in Afghanistan. And we spent a year really instituting changes. We moved. I mean, there had been a lot of efforts in the work to move from the Bagram Theater Internment Facility to a new multi-million-dollar facility to provide humane treatment, and to start training Afghans almost immediately to take it over and to do it to a high standard. And that was in 2009. So 2009 to 2010, I'm doing detention ops in Afghanistan. And then we created a rule of law field effort. It became a NATO mission as well. The ISAF nations voting it. So it was just a wonderful couple of years of trying to build capacity, serving the rule of law, getting Afghan trials going in the Afghan system, which are the most legitimate to do. I mean, we weren't going to be trying these individuals in a U.S. military court. The best way to get legitimate outcomes was to have the Afghan judges doing it. So we helped support that.
Abu Ghraib, where does that fit into this, and how did that affect the JAG morale? Because I got to believe somebody said, what the hell has just happened?
Yeah, I mean, this is now early 2004. Images are coming out from this in Iraq, and you start getting a series of investigations: General Taguba's investigation, the Schlesinger investigation, Church, a series of Miklashek, a series of investigations reveal that there had been a breakdown in a lot of different ways that led to these relatively junior soldiers on the night shift at Abu Ghraib in November, December of 2003, just not living our values and not and breaking the law. So the courts martial that followed wound up convicting, several of them. Grainer eventually got 12 years. Lindy England was convicted. A number of the soldiers there in a court-martial process that I think was very credible. It yielded a range of outcomes because there was a range of culpability, and but more important than the Army and the military undertook a series of reforms. One of which was to separate out the intelligence gathering function, the human collection, from the care and custody, ensure that military police who had detention training had the care and custody effort, and that they wouldn't be participating in any of the intelligence gathering, among many other systemic improvements. And I think the record speaks for itself. I mean, I think we instituted a lot of changes, created more transparency, brought in, lots of observers, and let people see it. And one measure of how it was working was that in Afghanistan, where detention operations were toxic in 2009, by end of 2010, the Brits are sending detainees to our facility. That shows you something. So, we have a messy form of government. We make mistakes. Americans, have always done that. What did Winston Churchill say? It's the worst form of government except for every other form of government. And the Americans will try they'll eventually get to the right place after they've done everything else. That's what kind of us.
During the administration, President Obama's election, and one of the things that he certainly made a big point during his campaign was Guantanamo and the closing of the Guantanamo Bay detention centers, and kind of trying to bring them into the federal court system. Were you part of that decision-making process, or ultimately as a president making that decision as commander-in-chief, this is a direction I'd like to go, but were you part of that process where he was trying to assist as to how that logistically could work out?
Well, no, I'm a professional military officer and have to provide best military advice, and that's the role in which I was brought into this. I was on a policy task force, but it was to provide, best professional military advice. So I was on it was the task force created under Executive Order 13493, the Detention Policy Task Force. There were two, and that was a forward-looking task force, Greg, looking at how do we best capture individuals, gain intelligence from them, figure out what to do with them, prosecute them, and convict them and then have some kind of long-term detention effort. There were two other task forces associated with an attempt to close Guantanamo. One was an interrogation policy task force, which almost immediately outlawed so-called enhanced interrogation techniques. And then there was a third task force, Executive Order 13492, which was kind of the Guantanamo closure task force. It was an intent to go in and look at all of the some 240 plus files and figure out, you know, what's the best thing to do with each of the detainees.
I'm looking up. We had here a few years ago as one of the guests at David Crane, Sig Libowitz, actor, lawyer, and he produced the film The Response.
Yeah, I've seen that.
Did you see that?
I have, yeah.
What was your sense of that? I mean, you got essentially the three judges trying to deal with that. Was that a reality check as far as the film?
I've seen that. It's a composite of a number of different things. I mean, this is a combatant status review tribunal, which was not it's not attempting to adjudicate guilt or innocence. In that situation, you have officers who are, you know, questioning what is the nature of the information they're getting about this individual. And it was the system that the Supreme Court reviewed essentially in Boumediene v. Bush in 2008. So, I mean, it's kind of an anachronistic. I mean, now if you were to look at it, it wouldn't have any resemblance to what protections the detainees have, because they all have the writ of habeas corpus.
Yeah,
I mean, now the people struggling over those kinds of decisions are federal judges. You know, what are you going to do? I mean, those are independent judges. They demand evidence. That said, they've approved the detention of a lot of the individuals still at Guantanamo. So I saw it. Well acted. You know, it's got some. You know, it's a quality produced piece, but it's no longer, you know, the situation there. And then of course we're trying to adjudicate guilt or innocence in the military commissions. We're actually, you know, trying to try them for crimes, and that's a quite rigorous process. It's not a board of officers with a personal representative, which is what you had in that case. You actually have, you know, very qualified defense lawyers. You got a lot of discovery, a lot of criminal discovery. We've got to turn over a lot of information. We got to do it in a way that's safe. So it's no, I'd say it was a provocative piece. You know, it stimulated a lot of discussion, and a lot of the criticisms that were imminent in that were the very ones that led to Boumediene v. Bush, where you get Justice Kennedy authoring an opinion. Actually, you know, authoring an opinion that you know, without overturning it, undercut Johnson versus Eisentrager, you know, from the Jackson era, when you had habeas corpus not being available to offshore, you know, out of the United States people. Essentially said no. Guantanamo, for the purposes of the non-suspension clause of the United States Constitution, is part of the United States.
Saboteurs trial. Is that part of your training and learning? Sure. No, we the Kieran ex parte Kieran case of the saboteurs, four of whom, or we have saboteurs landing in Long Island and Florida, and getting picked up pretty quickly because one of them goes to the FBI. That trial in 1942. Is still, you know, a big part of the jurisprudence on the issue of whether military commissions can try conspiracy. Factually, it's a fascinating case. I mean, these guys came here with very good training. They had a lot of explosives, properly packed with blasting caps and partitioned in such a way that they could blow up. You know, they could derail many civilian trains. They could wreak real havoc. It was a terror trial in a lot of ways. I mean, their intent was to terrorize. Not long after Pearl Harbor, the Eastern Seaboard is just, you know, very tense. And these were terrorists. They had coal bombs. You know, they had little explosives that could look like a piece of coal.
when you look at the photographs from the record and you see all the stuff they were caught red-handed with, I mean, you kind of see how the court came out where it did. That said, it's an opinion that arouses quite a bit of controversy and civil liberties during wartime and other kinds of things.
Well, they were actually executed before they wrote a decision.
Mm-hmm. Yeah, no, the per curiam opinion comes out afterward. Yeah.
I just sidebar. John Baer, who's the biographer of Robert Jackson, and myself spoke at Chautauqua, and we're giving a dog and pony show about Jackson, and a lady comes up named Gertrude Moretti. Gertrude Moretti, turns out, was a research assistant at Nuremberg, and subsequently wrote a play on the Saboteur's trial because she got all of the papers from the defense counsel. One of the defense counsel, the entire, he died, and she ended up with everything, and it was never published, never produced. So we did it at a play reading at the Jackson Center. It was really quite remarkable. Today, what keeps you busy? What? So you come here and you're relaxing. Hopefully, have a glass of wine. But aside from that, and you wake up tomorrow and you say, "Oh shoot, here we go."
No, we're working 7 days a week. This was a brief respite here because Dave Crane kind of convinced me to come. Certainly glad I did. But we have been working very, very hard to comply with all of our discovery obligations.
This is Guantanamo.
Guantanamo, yeah, no. So the management and just putting together these cases for all of these, alleged high-value detainees is a full-time job.
What's the scorecard for the camera? How many detainees are there, and how many are currently sort of in the trial track?
There are 41 detainees remaining at Guantanamo. There are 7 who are arraigned. There are 2 who are convicted but not sentenced. There's 1 who's facing a life sentence, and his case is kind of making his way to the Supreme Court. A couple of others who've been through the military commissions process and were there.
Let me pause for a second. What's the military commission? They get a judgment, sentence. What's the appeal? Where does it go? Into the federal system?
Initially, well, it's federal in the sense that it's not a state or local institution. Sure. It's an Article I court, so it's from our congressionally established organ. It's a civilian and military United States Army or United States Court of Military Commission Review, it's called, and it has civilian judges who are appointed by the president, confirmed by the Senate, and then military judges. It has a scope and standard of review that allows it to review the facts as well as the law. So it can actually look at the record and come to different conclusions, although it's deferential to the fact that the trial judge and the jury heard the evidence.
And it is jury? It's a jury trial?
It's a panel of officers.
Okay.
I mean, it's not a Sixth Amendment jury of one's peers, from the district wherein the crime shall have been committed, but it is a jury-based process. These are lay persons. These are military officers who are not lawyers, who don't have any connection with the case, who are subject to examination and challenge. So it's a court-martial type process. And then so the first level of review is this Court of Military Commission Review, which has, again, the same scope of review as the Courts of Criminal Appeals of a service member. Will go to a court of review that will look at the record on factual grounds as well as for legal error. And then the next level, Greg, is the United States Court of Appeals for the District of Columbia Circuit, Article III judge, lifetime tenure, salary protected judge, independent, Article III, and this is direct appeal. So then by petition for writ of certiorari to the U.S. Supreme Court.
So you got 41 on your scoreboard here, of which your 7 have been arraigned.
7 have been arraigned, and there'll be several others that we're planning to bring charges on. Right now, all 41 are under law of armed conflict detention, and they have for the writ of habeas corpus, and they have access to the U.S. courts.
How much your staff like? What's the size?
I've got about 150 people organically. About third each: prosecutors, paralegals, analysts, and then not organic, but working for us in direct support every day are about 20 to 25 personnel from the Federal Bureau of Investigation. There's a criminal investigation task force, which is DOD, law enforcement, so Criminal Investigation Division of the Army, Naval Criminal Investigative Service, the Navy, Air Force Office of Special Investigations, OSI, in support of us. And then, throughout the government on any given day, there are scores of people who are working these cases, from diplomatic aspects to, at the Department of Justice, doing things on our behalf to try to get us evidence from foreign countries, assisting us in that way. So it's a massive effort. And then the Defense Council teams are very formidable and very well resourced. I mean, a capital defendant will have a learned counsel, someone who under the statute has litigated death penalty cases before, several assistant counsel, a detailed military counsel, so a JAG who's detailed as a lawyer, an investigator, at least one investigator, a mitigation specialist, linguists, paralegals, analysts. It's a pretty large operation. I mean, these are important cases, and they're spanning a lot of territory, a lot of years.
Where are they stationed? In Cuba?
We go down there to trial the cases and to do all the proceedings. Most of them are the defense teams are all around the country. Where they've got office spaces in sensitive compartmented information facilities for the classified information they may receive. Of course, our affirmative case is all unclassified. We want the people are going to see the proof upon which these individuals were tried. But of course, mitigation, Brady, Giglio information that they may seek to put in for mitigation or challenging our evidence could very well could be classified. So they are in SCIFs in the D.C. area, and have the judges will typically work out of the D.C. area when they're not in Gitmo.
Is this an assignment you have of a certain term?
I'm long retirement eligible. I'm due to finish a 6 year 2-month period here this fall, and I suspect they're going to ask me to stay on for a while.
And you'll probably accept?
Yeah, I mean, I'm going to play some. Continuity can be helpful. There are lots of very, very talented people, but you wind up learning the ropes a bit, and you can provide a little bit of continuity. So I've offered to do that. My wife is an angel. She's also a former Army helicopter pilot with a great duty concept. So she said, "Don't think about leaving until you help them." And then my kids are grown.
Yeah.
So I'm in a position where I can do it.
When you do interviews like this, or even, what's a question you normally get asked that I haven't even begun to think about today?
You've done a pretty good job. I mean, I think the question, why does it take so long to do these things? And it has been a long time. I mean, these things, and I feel that every day because we have 20,000 family members of the fallen, of the victims, and we have one of the obligations of the prosecution in many systems, as ours, is to liaise with, to provide information to the family members, to give them opportunities to participate in the proceedings, be a witness in many cases. So that's a question they'll ask, and there aren't any good answers, but. One answer that maybe at least helps is that it's almost a measure in this kind of case of just how important these things are. As we got to work our way through, concerns about the treatment of these individuals once they were captured, We've got to ventilate that. We've got to have a sharply adversarial process that's as transparent as possible, so that when we conclude, we know that we've done it, and consistent with our values. And but that's why does it take so long? Is one of those ones that tends to wear on the family members, and you feel just a sense of urgency. That am I doing everything I can do?
Right.
Today, have I done everything I can do to move this thing forward a bit?
Do you find yourself in front of congressional hearings?
No. We try to keep prosecutors out of that. There are political appointees in the Pentagon who can go talk to them. I do have I have a limited outreach process. I've been far too busy since 2014 to get out. I was trying to go for go once a month to an informed audience. Not a place where we're going to get into a demagogic kind of situation where people are just sort of taking pot shots. And people who really want to understand the law schools and civil society groups that are interested or had observed at Gitmo. Now what I do is I speak to I do a media roundtable every time we're starting a week of proceedings. I'll meet with certainly meet with the family members every night almost, meet with the civil society organizations that come down to observe, and then at the end of the week I'll do a roll-up and I'll explain what happened again to the media. That's a bit more of a stand-up thing. And those are all put on the website. All that stuff is there. Our transcripts are on the website. We transmit proceedings to the continental United States. They're not broadcast, but they are available for watching if you go to the courtroom, the extension of the courtroom in the National Capital Region. So, so we do some outreach. We definitely try to inform the Congress. We'll answer queries. We will provide input to various Pentagon legislative affairs people to help them understand where things are. And we do have congressional delegations come to Gitmo to observe and things, but I'm not briefing them typically. I'm independent. People let me do my job, and I have to occasionally go for resources. I have to go for coordination of important policy positions that may be implicated by our litigation to make sure that my client, the overall United States, is properly represented, which means we've got to have a coordinated position across State Department, Justice, DOD. But I typically steer clear of the hill.
This has been terrific. You've been terrific. Thank you.
Oh, thank you
for sharing all your
Thanks
time.
for welcoming us to your beautiful piece of the country here.
Yeah.